So the reason why breaching an antisocial behaviour order is contempt of court is because the alleged contemner is acting in defiance of a court order endorsed with a penal notice. Now, the contempt can be brought to the court's attention in one of two ways in respect of antisocial behaviour. The first is an application for contempt of court, a committal application brought by the other party to the litigation, the claimant, the party that obtained the injunction. The other way the court may find out about the alleged contempt is by way of arrest, where the injunction includes a power of arrest. So if a person is arrested for breaching an injunction, they'll be brought before the court within 24 hours, where the alleged contempt of court will either be resolved or adjourned until a later date. Now, for the purposes of my talk, I'm going to focus more on the application procedure rather than the power of arrest procedure. But before looking at the procedure, I want to bring to your attention the need to ensure that the underlying injunction is capable of enforcement in its terms. Because you shouldn't assume just because the court granted the injunction, it will allow you to enforce it. This case from last year, Connexus Homes Ltd and Mr. and Mrs. Weaver, Court of Appeal, is a good example of a case where the court, or in this case, the Court of Appeal, has prevented a claimant from enforcing an injunction that the lower court granted. So the Weavers lived in social housing. In their garden, they had a number of outbuildings, including kennels for 6 dogs. The housing association wanted to inspect the property, but the Weavers wouldn't allow it. Under Section 2, paragraph 11 of the Weavers' tenancy agreement, their home was defined as including any garden, garage, or outbuilding. So plainly, the kennels and the outbuildings were part of the home and subject to the access obligations under Section 2, paragraph 11 of the tenancy. So they were in breach of the tenancy agreement. The landlord applied for an injunction. It was a standard access injunction and not an antisocial behaviour injunction, but the principle applies in any event. The injunction was granted, and the sole requirement of the injunction was, and I quote, "The Weavers must comply with Section 2, paragraph 11 of their tenancy agreement, dated 6th of April 2009. So essentially, the Weavers were ordered to comply with the provision of the tenancy agreements that related to access, and which included the definition of their home. The access issues continued. The Weavers genuinely believed that the kennels were private property that the housing association weren't entitled to inspect. And they thought that because they constructed the kennels themselves. And accordingly, they breached the injunction. They didn't allow access as required under the previous injunction. The housing association applied for contempt of court. They applied for a committal, a finding of contempt of court. Findings of breach were made. The district judge or the circuit judge, I can't remember which, adjourned sentencing in the hope that the Weavers would allow access to the kennels. They didn't allow access, and ultimately the judge imposed a suspended term of imprisonment. At the contempt hearing, or the contempt hearings, the Weavers were represented by legal aid solicitors and counsel. Following their sentence of suspended imprisonment, they appealed to the Court of Appeal as litigants in person. So they went to the second highest court in the jurisdiction as litigants in person, and they won. The Court of Appeals set aside the findings of breach and the sentences. The Court of Appeals said that the injunction was unclear. The person reading the injunction, a layperson, would need to read the injunction itself and then cross-reference it with the tenancy agreement to understand what they were required to do or what they were required not to do. In the Court of Appeal, Lady Justice King said the following, and I quote, and it's on there on the slide: "The principle of justice and fairness demands that no order will be enforced by committal unless it is expressed in clear, certain, and unambiguous language. The injunction upon which the application to commit was founded, and upon which an order for suspended imprisonment was made, unfortunately failed to satisfy the long-standing requirements for absolute precision where an injunction is made. As a consequence, the appeal must be allowed, and the findings of contempt and the sentence of imprisonment be set aside." So even though the lower court granted an injunction, it wasn't enforceable because it was unclear, uncertain, and unambiguous. And as I noted a moment ago, the Weavers were successful on that argument. The key takeaway is essentially that your injunctions need to be expressed in clear, certain, and unambiguous language. And if you have any injunctions that aren't expressed in such terms, that are ongoing, you might want to go back and have a look at them and decide whether you need to apply to vary their terms. From the point of view of people defending tenants or the like involved in these types of proceedings, well, I think the takeaway for you is that you look at the injunctions against your clients, and if enforcement applications are made, you can use this case to defend them, to argue that the court dealing with any committal application shouldn't enforce an unclear, uncertain, or ambiguous injunction. I want to talk briefly now on the procedure for making a contempt application. The application is made under Part 23 CPR, and that's confirmed in CPR 81, but don't use the N244. The correct form is the N600. It's an application notice, but it includes all the information that is required to properly bring a contempt application, including the defendant's rights in the procedure. For instance, his right to silence and for to be assisted by a lawyer, etc. So that's all in that particular application form. So that is the application form that I suggest that you use rather than the normal application notice. Now, unless the court orders otherwise, all written evidence in support of the application must be in sworn or affirmed format. It shouldn't be a normal CPR witness statement. And it's there on there, so it must be supported by affidavit or affirmation evidence as applicable. Service of a committal application is of very significant importance. A defectively served application will sink an application. It has to be served properly. The default is personal service. That is what's required by the civil procedure rules and by the substantive law of contempt. But there are exceptions. The first one is that the court can dispense with personal service on an application. The second one is that the legal representative on record for the defendant in the same matter, so if a defendant's solicitor remains on record following an injunction, following injunction proceedings, it can be served on them, but the solicitor has 7 days to object to service. In my view, if you're going to make one of these applications, personal service is always the safest option. I wouldn't bother trying to serve on the solicitor because they will almost inevitably reject service of it. If the alleged contemner is evading service, then you may go back to court and seek a different order. You can make an application to serve by post or something of that nature. Just in relation to some evidential matters, the burden and standard of proof. These are civil proceedings, but because the liberty of the subject is at stake, the court applies the criminal standard of proof. So the claimant must prove every allegation made individually. So by that I mean, if 10 allegations are made, each one must be proven. And by that I don't mean you have to prove every one of them to succeed, but you must prove each allegation. So if you might prove some and not others. That's all I mean by that. The standard of proof is the criminal standard of proof. So the claimant must persuade the court so that it's sure the defendant has committed the individual breach. The balance of probabilities is insufficient. It is the criminal standard. The defendant is entitled to remain silent in the application. And by that I mean he's not required to answer the allegations made against him. However, the court can draw adverse inferences from his silence. So silence isn't a shield as such. If he doesn't speak in the proceedings, the court can draw inferences from that. And one of those inferences may be that he has no answer to the allegations that are made against him. Civil Procedure Rules, Rule 81, Spot 7, Subrule 3, confirms that the court may not give any direction compelling the defendant to give evidence either orally or in writing. So he can't be compelled to give any evidence. An interesting side effect of that is that the defendant can attend a final contempt hearing and give oral evidence even if he hasn't served a witness statement. He's entitled to be heard, either in writing or orally, or both. So there's no point in arguing at such a hearing that he needs relief from sanctions to give any sort of oral evidence. It simply doesn't apply here. He can give oral evidence in his defence at the hearing. And because of that, his initial evidence may be obtained by traditional examination in chief, so the claimant may be taken by surprise by the evidence, but that's just the way it is in these types of cases. So I'm going to touch on sentencing quite briefly. Obviously, this assumes that the person has been found in breach of the injunction to get to the sentencing stage. If no breach is proven, then there'll be no sentencing exercise. There are 5 options open to the court on a finding of contempt of court in respect of sentencing. The first and most draconian penalty is committal to prison. The maximum sentence is 2 years imprisonment. The second option is suspended committal to prison. So that's where a committal order is made, but the contemner doesn't have to go to prison there and then, subject to compliance with certain conditions that may exist. Very often, if they don't get into further trouble, it'll just run its course. The third option is a fine, which is a financial penalty. And the fifth and final option is no penalty at all, which is, I suppose, analogous to an absolute discharge or in criminal proceedings. Just a word about adjourned consideration. That is probably the court's favourite sentence in an initial breach of an antisocial behaviour injunction. Essentially, the court will indicate to the defendant what sentence would have been passed had it been resolved or had he been sentenced on that particular day. For instance, it might be, 3 weeks imprisonment suspended for a month or whatever. But instead of passing that sentence, the court adjourns sentencing until a later date to see if any further events happen. And if on the adjourned hearing there aren't any further breaches or further allegations of breach, then the court will look at sentencing afresh and very often will pass no penalty at all. Obviously, if you go back after an adjourned consideration and further breaches are proven, then it's unlikely there will be a lenient no order sentence. In terms of sentencing guidelines and the framework for sentencing, they are set out in the case of Wigan Borough Council and Lovett, which appears at 2023 One Weekly Law Reports 1443. If you do this type of work, you should be familiar with this case, and if you're just getting into it, then it's probably a case that you'd want to have a look at. Essentially, the court carries out the sentencing exercise by, first of all, assessing the seriousness of the breach. And it does this by assessing the level of culpability and the level of harm. Using the level of harm and the level of culpability, the court is then able to establish the sentencing framework, which is set out in a table that appears in the judgment itself. And that table allows the court to ascertain the starting point and the sentencing range. And the starting point is just the sentence the starting point for calculating the sentence. So for instance, it might be a starting point of 1 month with a range of adjourned consideration to 3 months. And once it has the starting point and the sentencing range, the court will then go on to look at the aggravating and mitigating factors. And this will allow the court to adjust the starting point or adjust the sentence from the starting point into the appropriate place within the sentencing range. Having identified the sentence, if it is a custodial sentence, then at this stage the court will consider whether to suspend the sentence. Some tips to avoid difficulties in these applications. First one, make sure your injunctions are clear, certain and unambiguous. Check the underlying injunction was properly served on the defendant, because if it wasn't binding on him and you can't make an application to commit. Ensure the committal application is properly served. I've covered that. If your injunction contains a power of arrest, be sure to serve the injunction on the defendant before sending the power of arrest to the police, because what you don't want to happen is for the police to arrest the individual before he's been served with an injunction. So that's an important point. When making the application, use the N600. Make sure each allegation is set out individually. Attaching a Scott schedule to the application is probably a safe way of doing that. And get service rights. I think I might have said that already. And ensure the evidence, the written evidence, is in the proper format. Don't use witness statements unless the court has authorised it. The starting point is affidavit or affirmed written evidence.